I would start with noting that if the new discovery is the state's contact of witnesses we've listed, the state knows that there are mitigation witnesses that we've listed because we had to disclose them, but they are people that have refused to speak with us. That presents a challenge in the case. A lot of the witnesses that refuse to speak with us have to do with records, medical records of Bryan Kohberger, past treatment records of Bryan Kohberger. Those are important things that the gravity of what they have to say can't be known to our experts until we have the opportunity to fully understand those things. And we continue to work on access to witnesses and access to additional information. Your Honor, I want to touch on just a couple of points. One, when the court considers a continuance and considers whether Bryan Kohberger's rights are violated, his right to a fair trial, his right to confront witnesses and evidence against him, his right to present a full defense, and his right to effective assistance of counsel are implicated and laid out in our motion to continue. The ABA guidelines require us to do a full investigation. It's not going scorched earth to understand Bryan Kohberger's full life history. These are things that are required. And we've done everything that we can. We have had a mitigation expert on the case. This is 2.5 years into a case, and the average for capital cases is 3.5 years.
In federal court.
In federal court.
Which moves at a snail's pace in its best day in regular cases.
I'm not a practitioner in federal court, so I don't have any basis to talk to the court about that. But what I can tell you is that a capital case where we have a client and we need to investigate both the merits phase and a penalty phase at the same time takes time. In any case, it takes time to do that. In this case, with the high profile nature and having people decline to talk to us presents a whole set of challenges that we have to find a way to work through. As the court knows, a lot of mitigation information is very sensitive information. It takes some time to be able to get people to talk about things. Realities exist too. Not all of the family members are in the same place. So there's travel that's required. All of those things take time to do in a case like this. 2.5 years is excessively fast to put all of that together. There was no delay in having a mitigation expert on board. There was no delay in getting investigators to work on the case. And as soon as issues became apparent, Mr. Kohberger's team did not delay in getting experts to help us understand specific areas of the case. Looking over the entire record, the court can see that the defense team has been diligent about discovery, about motion practice, about litigating issues in the case. There just still is a lot left to do. There is still a lot left that is not known. And Mr. Kohberger has a right to go to trial with prepared counsel that have conducted a full investigation in both phases of the case. When you have a certain amount of information and there's this other stuff that's out there, that's a red flag, that's real, that you need to investigate, your experts can only do what's here, what's been investigated, what's been produced for them to assess. This whole other area, that land between the red flags and the investigation, that's an unknown area. That's where there's ineffective assistance of counsel. That's where there's not a fair trial. That's where there's not an individualized sentencing proceeding. And it's that area that requires a continuance in this case.